Welcome back to NCBA Coffee Break, where we take complicated legal issues, break them down over a cup of coffee, and try not to bill each other in 6-minute increments while we do it. I'm your host, Nathan Willner, and today we're diving into an NCBA amicus brief in a case that goes right to the heart of creditors' rights and honestly, the Constitution itself. Yes, we're talking about the FDCPA and the First Amendment. So if that sounds like the start of a law school exam question, don't worry, we'll keep it practical. Joining me today, Pete Nanov, attorney at Saul, Ewing, and the drafter of our brief, and Ron Miller and Brian Chou, co-chairs of NCBA's Amicus Committee. Gentlemen, welcome. Let's go ahead and start with Pete. What's this case really about?
So at its core, this case pending in the Eighth Circuit asks, can a creditor or its attorney be held liable under the FDCPA for statements made in good faith during litigation, even if those statements later turn out to be either wrong or disproven or not accepted by the court through the adversarial process? More specifically, in this particular case, the appellants argued that even routine litigation activity, such as the allegation of an amount due, could create FDCPA liability regardless of intent if that amount due is later determined to be something else.
So before I ask my next question, I guess we should have given the name of the case. And Pete, can you go ahead and give us the name and the citation for our listeners so we know which case we're talking about?
Sure. It is Prigge versus Landlord Resource Network. It is actually a consolidated case of three different cases. The lead case number is 26-1037, again, pending in the United States Court of Appeals for the Eighth Circuit.
All right, thanks. So this isn't about abusive collection tactics. It's about what happens inside the courtroom, correct?
That's exactly right. It's about the pleadings filed with the court and what happens in the courtroom and the determination that the court reaches. And that's the key distinction here, is that the FDCPA clearly regulates abusive practices, but this case pushes the question into whether it also regulates or can regulate good faith legal advocacy.
So, Ron, where does the Constitution come in?
Well, thank you, Nathan. So this case implicates the First Amendment right to petition the government, which includes access to the court, filing a lawsuit, making arguments, requesting relief. That's all petitioning activity. And lawyers must be able to work with their clients as trusted partners, relying in good faith on the information and materials that are provided by the client. While appropriate diligence is always necessary, and of course, any clear and obvious red flags should be investigated, there's no general expectation in the legal profession that attorneys conduct independent investigations or audits of their clients' books and records before relying on what the client has provided us. And, this principle is particularly important in a broader, more practical context. For example, in the collection industry, many of our cases involve relatively small balances. So if attorneys were required as a matter of course to retrain forensic accountants or private investigators to independently verify the accuracy of every client representation, they would ultimately undermine meaningful access to the courts. So maybe to put it in a different context, a system that provides attorneys to reasonably rely on what their clients are telling us while remaining vigilant for indicia of inaccuracy or misconduct strikes that necessary balance between professional responsibility and practical access to the courts, which is, of course, justice.
Yeah, and Mr. Miller, the Supreme Court has made clear that the courts should not interpret statutes, right, in a way that would burden that right, unless Congress, clearly intended it.
So, Brian, why did this case trigger NCBA to get involved?
Well, first of all, NCBA is on top of all sorts of legislation and does great work on behalf of its members. So we would expect them to get involved, especially with a good partner like Mr. Nanov there. But the implications to the members are significant. I mean, that's why. If the appellant's arguments here were accepted, it would mean that we attorneys would be liable for good faith mistakes in litigation. Creditors counsel, we would have to act like a guarantor almost of every factual assertion that we would make. It's our client's evidence, and we're going to have to be a guarantor of each one of those and what could be complex, long-standing financial history transactions that they have, and it would fundamentally change how collection practice and litigation works.
Yeah, so that sounds like more than just a technical shift.
I think it is. I think it would create a chilling effect. Attorneys would be hesitant to bring legitimate claims because of fear of FDCPA liability every time they file a case, especially one with long outstanding transactions, long history of transactions.
So fewer cases filed, not because they're invalid, but because the risk is just too high?
That's exactly it. And what it does is it impairs the creditor's ability to access the courts, which is a constitutional issue that I spoke about earlier.
Yeah. So, Pete, from a practitioner's standpoint, what's the practical problem here?
Well, the adversarial nature of our legal system assumes that facts are tested through litigation, not guaranteed in advance. The whole idea is that the system itself produces the truth, rather than either side having a monopoly on truth from the start. So if attorneys can be punished simply because a claim doesn't succeed, or a number is later adjusted, in addition to being inconsistent with the nature of our system, you're also asking the attorneys to go above and beyond what any other attorney would, in a litigation capacity, would be. And as the other gentlemen have said, that would turn collection litigators into auditors and insurers and supposedly zealous representatives and litigators on their client's behalf all at once.
So, all right. So let's get into the substance. What did NCBA actually argue in this brief?
So we made three central points. The first one was that the First Amendment protects litigation activity. And the First Amendment contains the right to petition, and it includes the right to access the courts. And the courts have all recognized that and the Supreme Court has recognized that even unsuccessful lawsuits are protected. A claim isn't false or doesn't become false just because it loses. Litigation activity is generally immune from attack unless that litigation can be proven to have been brought in bad faith or as a sham. And the second main point is that the FDCPA does not override that First Amendment right to petition. The Supreme Court has already said that the FDCPA does apply to attorneys, but that it cannot be interpreted to produce absurd results. And as mentioned earlier, the Supreme Court has also said more generally that it will not interpret statutes to restrict First Amendment rights unless Congress specifically says so. But again, here, the FDCPA does not eliminate the creditor's rights to pursue legal remedies. So clearly that was not intended by Congress. And even strict liability statutes, such as the FDCPA, must cede to the protections of the First Amendment. So in our brief, we emphasized that the good faith litigation protection doesn't come from the specific language of the FDCPA, which is the context in which the appellants are strictly within the FDCPA, but rather that it comes from the Constitution. And the third point that we argued was that this court has already recognized a good faith litigation standard.
And I would also add that, the Eighth Circuit has been a great circuit for establishing this point. Courts, especially in this circuit, have repeatedly held that attorneys are not liable for good faith arguments in the pleadings. And statements that are made to courts are part of this petitioning activity of the First Amendment. So if there's going to be liability should require more It should require something like bad faith conduct.
Right. So if I'm the way that I think about this, and the way I'm hearing you gentlemen talk about it, it's and the way I feel about it, we're not creating some sort of new rule here, right? The argument is based on preserving a longstanding fundamental precedent, and that fundamental precedent is grounded in the Constitution.
Exactly.
And we also made a general practical and policy argument as well, was that the appellant's argument would effectively turn the FDCPA from a shield into a sword. And various courts have ruled that the FDCPA is meant to be a shield against abusive practices, not a sword against legitimate litigation. So if you allow FDCPA claims based on good faith litigation, or then every unsuccessful case could spawn a new lawsuit. Costs would go up, the system becomes less efficient, and the FDCPA changes from a shield into a sword wielded by enterprising plaintiffs' lawyers, rather than its purpose to guard against abusive practices.
So instead of protecting consumers, it in essence would distort the system.
Well, that's exactly right. It creates follow-on satellite litigation, possibly from every single collection case that's filed, without improving any aspect of fairness.
Yeah. So what's the impact if the court adopts NCBA's position that's set forth in our brief?
Yeah. Well, I think it reinforces fundamental, litigation principles. It allows attorneys the ability to advocate on behalf of their clients without, what I would characterize as undue fear. Finally, I think it reinforces again the balance, the proper balance between consumer protection and creditor rights.
And I like that terminology, the proper balance, because it's supposed to be a level playing field. The purpose of the FDCPA is not only just to protect consumers from abuse, but also establishing a legitimate manner to have collections and not punish legitimate legal advocacy for our clients.
What happens if it goes the other way?
Well, then we can expect increased litigation risk. Fewer attorneys willing to take on creditors' cases. That's the chilling effect that Ron spoke of earlier, and ultimately impaired access to the courts.
Yeah. So we're getting close to the end of our cup of coffee, so to speak. And this has been a great discussion. Pete, Ron, and Brian, thank you so much for walking us through what could be seen as a complicated issue. For our listeners, the takeaway is simple. This case isn't just about one lawsuit. It's about whether a good faith legal advocacy can exist without fear of liability. And if you've made it this far, congratulations. You've just spent your coffee break talking about the First Amendment, statutory interpretation, and adversarial process theory, which officially makes you the most fun person at your next networking event. Thanks for joining us on NCBA Coffee Break. Finish that coffee, get back to your cases, and remember, sometimes the biggest legal battles happen in the footnotes in the Amicus briefs. I'm Nathan Willner. See you next time, and stay caffeinated. Thanks, everyone.